that kind of work. The way the human rights field has developed, Your Honor, is that initially the world had set up standards internationally, and then these standards had been incorporated into national law. But I think we are at a point where for human rights to be meaningful to the poor especially, we must work now on the delivery of justice. And being in the Supreme Court would really put me in a position where I could do something about the delivery of justice.
Which brings me to my next question, Dean. What specific reforms would you propose in the study of law, in the practice of law, in the bar examinations included, which would serve to improve the service of lawyers as justice, as officers of the court, and as partners in the administration of justice?
There's a lot of things I think that need to be improved as far as legal education is concerned, not just for the skills of lawyers, but also in terms of their values and ideals. For me, a good legal education would entail not just teaching our students how to be a lawyer professionally, meaning the skills needed, but as well the values to be a successful contributor to national development.
Could you be more specific as to what values you would like to espouse and to be promoted among the law students?
First and foremost, I think would be a strong orientation towards human rights. Because for me, human rights is really the bedrock. It's the foundation of a legal system, especially in a developing country like ours, where so many of our people are poor. I think that our legal system must be oriented in that manner. And for that to happen, we must begin with the students.
Thank you, Dean. There are some sectors who claim that and who have signified their opposition to your nomination, stating that you have an institutional, and I quote, an institutional and personal bias against men in uniform, the AFP and PNP, and for the Arroyo administration. Would you care to respond to that?
Well, I would beg to disagree with that. I have had many clients also from within the Army and the other members of the Armed Forces of the Philippines. I have represented both so-called leftists and rightists and centrists. To me, the labeling doesn't matter. What matters are the merits of the case and whether I can defend my clients or not.
You mentioned earlier that you would also want to institute reforms in legal education. Do you believe that having the multiple choice questions in the bar examination is a move towards that step?
Well, it is one of the moves I think that we have to do because of the number of students that are taking the bar. But I think that there are as well other skills that must be tested in the bar examinations. And I'm happy to hear that in this coming exam, the essay format will still be put back in. Because I think for lawyers, especially, the ability not only to communicate orally, but in writing is essential. And is even as far as the court is concerned in evaluating the bar examinations, I think it's important that there be set standard prescribed criteria to assess the student's performance.
How much premium would you give to student internship programs, especially if you would like to promote human rights?
I would give it the high priority, not just internship, as well as I would include legal aid. I think that legal aid should become more common in all the law schools. It's a good idea for us to tap the law students while they're still in law school, expose them to the reality of the justice system, and let them learn for their own eyes how to deal with that system.
Now, as regards legal aid, there is a pending bar matter which has yet to be revived, and I'm referring to what was called as a mandatory legal aid service, and which was renamed as comprehensive legal aid service, mandating that all lawyers should be required to render legal aid. Don't you think that making it mandatory would just be legislating or the compassion? Because I said, if legal aid is supposed to be an act of compassion of lawyers and law students, then you're either compassionate or you're not.
Yes, Your Honor, that is one of the criticisms of the mandatory legal aid system. In the United States, the American Bar Association, legal aid is not mandatory. But based on the studies that I saw there, a lot of lawyers give legal aid, perhaps even more than in a system where it is made mandatory. That's why I would take a slightly different approach from requiring legal aid to be mandatory. I don't think you can compel that kind of service. And even if you did, the quality of work that might be provided by the lawyer would not exactly be the same as the one they would give a paying client. So I would also look to the law firms that have more resources to also give a little bit more than the other firms perhaps that don't.
You have no qualms of the proposal for some parties who may not be able to render legal aid to just contribute to the fund that would help other legal aid lawyers in pursuing.
In that respect, no, but I don't think it would be sufficient for them to comply with their duty to provide pro bono services. They may give money, but I think every lawyer should still help a poor client.
Moving on, I'd like to ask you about something that I think you have personally experienced. What do you think was the purpose of in the Constitution when it requires the filing of SAL-Ns, but that such disclosure to the public will be in a manner provided for by law? You have been required to submit a SAL-N, and you have expressed that you have found difficulty in complying with the same. What are your thoughts on that?
Well, a SAL-N is really important for all government officials. It's not only the baseline to determine whether they will acquire ill-gotten wealth during their period of tenure, but it's also a way of determining conflicts of interest, especially among the judiciary. I have nothing against, in fact, I'm in favor of filing a SAL-N. My only problem, Your Honor, was I only learned of the requirement Friday afternoon, and I was supposed to submit it by Monday, and it would be wrong for me to submit a haphazard SAL-N. After all, that's going to be filed for posterity. I would like to make sure that everything that I can include there that should be declared is fully complied, and it's difficult to do that in the span of 24 or 48 hours.
Do you believe that a SAL-N should be immediately made public, or there should be a law that would regulate how the SAL-N is?
I believe that the SAL-N is already covered by Republic Act 6713, and that the restrictions imposed by that law and the rules for access by the public should be followed by all branches of government.
Thank you, Dean. Moving on, we have a rule-making power of the Supreme Court under Article 8, Section 5, Paragraph 5 of the 1987 Constitution. And how would you use this rule in order to address the issues of delay in the disposition of cases and in order to allow the underprivileged access to justice?
I'm not sure that the issue of delay can be directly addressed by the issuance of a new rule. We already have a lot of rules that were designed especially for the poor litigants. Perhaps a greater re-examination of how we conduct our trials is something that would benefit us in terms of dealing with the problem of coming up with faster and cheaper justice. For me, for example, one of the biggest problems that we have as far as delay is concerned is we suffer from a lack of judges. The 26.9% of our trial courts have no judges. That means more than 1 out of every 4 trial courts ay wala pong judge. Of course, we cannot deal with so many cases being filed until we can address that problem of a national vacancy rate. Another problem that we have is many of our trial judges are fond of making evidentiary rulings that do not specifically decide the evidence, for example, of the prosecution. So a judge will say, oh, your evidence is admitted for whatever it's worth. And now you have the defense counsel saying, I don't know what evidence has been admitted by the prosecution, so I will now adopt a shotgun approach. I will present as much evidence as I can because I want to ensure that my client is acquitted. And that really causes a cluttering of the record and also as well a lot of delay. A third problem I think we have in our court procedure is the lack of a mechanism for pre-trial motions to suppress. If only we could adopt that mechanism, which has been followed in the States and in many other countries, many cases that reach the Supreme Court after 15 years and are thrown out by the Supreme Court, for example, for lack of counsel in a confession. Yun po sana, sa pre-trial pa lang natapos na yung issue na yan. And we would save a lot of money and a lot of time if we could adopt that kind of procedure.
Thank you, Dean. If I may just say something with respect to your observation that there are 26.9% of our courts that are unfilled, it may interest you to know that we are now trying to trim down that percentage by ensuring that all courts, regardless of caseload, will be filled as soon as possible, and that although we are experiencing difficulty in filling up courts in the remote areas, include especially in Tawi-Tawi, there are no applicants. So perhaps you might want to encourage your friends to join the judiciary and volunteer for the far-flung areas.
One of the other things, Your Honor, that I would like to see happen is that even in law school, our students will already be given the track, be offered the opportunity to enter the judiciary. Perhaps in the future we could have a system where when you enter law school, you will already elect that if you want to become a judge, you can take certain special courses that will qualify you for the pre-judicature requirements, so that later, at least from the time they're in law school, we can already form their mind into believing that they will be judges of the country.
Unfortunately, also, we don't have a system of internship in the courts.
That would be nice too.
What safeguards would you give, assuming that we would allow clerkship in the courts to ensure that the issues of confidentiality does not become a problem?
I think the clerkship is a very good idea. It's been done very successfully in other countries, Australia, I believe, in the States and other developed countries. We could probably copy from them, get the same kinds of safeguards that they use initially, and then develop our own from there.
Thank you, Dean. My last question. You have a lot of good proposals. You have a vision as to what you would want our courts to deliver to the underprivileged. But how will you get, if you are appointed Chief Justice, how will you get the present members of the Supreme Court who are more senior in age and who have more judicial experience to support your proposals?
I don't think any amount of talking to them or convincing them will do it. It will only have to be by example. That's the only way that I know how to lead.
And by that you mean?
I mean that I will not ask anything of the other members of the court that I will not willingly do myself.
Thank you. That was my last question. Good luck, Dean.
Thank you.
Thank you, Justice.
Attorney Mejia.
Thank you, Mr. Chairman. Good afternoon, Dean Joc. No?
Good afternoon, sir.
As Attorney Cayos pointed out earlier, this is not the first time that you're going through this process, as in fact, we interviewed you more than a year ago.
Yes.
If you will be appointed as Chief Justice, you know that you will be the ex officio chair of the Judicial and Bar Council.
Yes, sir.
And having seen the process of vetting candidates like you to the position, what reforms, if any, would you introduce in the process of vetting candidates for the position?
I'm very happy to hear that question, because I do have a lot of concerns about the process of appointment of judges. And I don't mean to refer to the Judicial and Bar Council itself, but rather to the system of appointment. I understand that in other countries they have made it less politicized by giving some of the power to the citizenry. Not all members of the Judicial and Bar Councils in some other countries are appointed by the President or members or considered public officers. Perhaps that would be one way of democratizing the process. I see, for example, in front of me, I believe all the members of the council are members of the bar. But being appointed a judge is something that all Filipinos citizens have a concern with. And I think that other sectors in society also have an equal interest in terms of deciding who should get into the short list. So I would like to see a greater participation, not only from within the bar itself, but from the other sectors of society.
Coming from the academe, Dean, how do you intend to continue regulating the law schools? Will you also introduce any reform in the manner by which law schools are regulated?
Well, that, as I understand it, is now primarily the function of the Legal Education Board. But insofar as my position, if ever I'm appointed as Chief Justice, I would like to see, for one thing, legal aid made a requirement, perhaps, or at least highly encouraged. among law students. Sa medical profession po, when you become a doctor, you have, I think, as up to now, you're still required to render community service. Perhaps something like that will help, because a lot of the problems, especially of the poor, could readily be resolved even by a new lawyer. All they need is access to counsel. Unfortunately, in our country, it's very hard for many of our brothers and sisters to get that access.
Talking about free legal aid, and given your background as a flag lawyer, do you think poor and indigent litigants are properly represented in our courts of law today?
There's a lot to be desired as far as that goes. I really feel for the PAO lawyers, because when I go to court and I see them, talagang punong-puno po sila ng kaso. Many of them have a difficult time, not because they're incompetent, but no, it's because they just have too much work and they can't do it. We don't have, unfortunately, a system here, a local system of appointment of the official counsel that is as active as in other jurisdictions that I've seen. In many other places, they have a roll of attorneys in every local court, where when they need the official counsel, kung walang power, if it's an important case, they can appoint from that. And I think those kinds of systems should be revived.
What, to your mind, are the key hindrances to the efficient and speedy disposition of cases, Dean Jock?
You're referring, sir, to the criminal cases, pre-sentence disposition?
All cases, for that matter.
Well, for one thing, I think that we have been applying rules of court and rules of evidence that were designed for a different system. We apply our rules of evidence, we lifted that from the Code of California. Our rules of court are mainly copied from the federal rules of civil and criminal procedure. I have no problem with getting rules from other countries, but the problem is, ang America po is a jury system where they have to have very strict rules because the judge and the jury are separate persons. The judge is the one who screens the evidence so that the jury will not hear it. But in our jurisdiction, the judge and the jury is just one person. The judge actually hears inadmissible evidence. It is now up to him, because of his training, to be able to screen that out in order not to make it influence his decision. So I don't think many of the rules that we have really, which were designed for a jury, can be streamlined so that we can apply it to a bench jury system that we have here.
For my final question, in your opinion, did the impeachment of the former Chief Justice infringe on judicial independence? Why and why? Why or why not?
No, I don't think so. And I think that the impeachment of the Chief Justice gave the people a number of lessons. The first lesson, I think, is that the people are also looking for transparency, not only in the executive and the legislature, but also as well in the judicial branch. And one of the issues, of course, there has to do with the statement of assets and liabilities of the Chief Justice. I would like to see a more transparent judiciary, both in respect to the SAL-N rules as well as in respect to its use of funds.
As I said, that's my final question. Good luck, Dean Joknay. Thank you, Mr. Chair.
Thank you, Your Honor.
Justice Lagman.
Thank you very much, Mr. Chair. Dean Jokno, good afternoon.
Good afternoon, po.
You stated a while ago in answer to the question of Attorney Mejia about the effect of the impeachment of the former Chief Justice. Now, considering the negative effect of that impeachment, in your opinion, what kind of a Chief Justice do we need today?
To me, thank you, Paul, for that question. To me, the biggest problem facing the judiciary is the people's loss of faith in the system. I would not even use the word public confidence, because for me, it's even deeper than that. Karamihan po ng mga kapatid natin hindi na po naniniwala sa husgado. And it's really unfortunate, but that will have to be the very first priority of the next Chief Justice. How could he address that? Well, if ever I am appointed, I would address it with a 4-point program. First, I would call for more judicial transparency. Second, I would call for more public accountability. Third, I would call for no more flip-flopping of decisions that are final in nature. And fourth, I would call for faster and cheaper justice. If I may explain each of these 4 points, Your Honors.
Yes.
First, I think, as I said earlier, the people to restore the people's faith in the judiciary, we must show them that the judiciary is transparent. And transparency can only be reflected in two ways: in terms of access of the public to the statement of assets and liabilities, and in terms of the use of public funds.
Yes.
And I think the Chief Justice will have to take the role, the lead, as far as those two matters are concerned. As far as public accountability is concerned, I have this very, very serious issue. Up to now, Your Honors, please, our courts have no central monitoring system to determine if a person convicted by final judgment, meaning already affirmed by the Supreme Court, is actually serving time in jail. We have no central record system to determine where, in fact, those people are. Now, how can we have a state of accountability if we cannot even tell how many of those convicted by final judgment are inside Muntinlupa? So to me, it's really very important that not only the courts but the Department of Justice and the Ombudsman realign their priority, not simply for conviction rates, but to determine whether those convicted are actually serving their sentences. I understand that there was a study made around 2007 or 2006, and it was submitted to the Ombudsman, where the study reported that out of 100 or so convicted of corruption-related offenses, only about 10 were actually in jail. Now, I do not know if that study is accurate, but if it is a very disturbing statistic. Second, I would call for the perpetuation, I would call for the review of the rules of court to allow for the perpetuation of whistleblowers' testimonies and other witnesses who are vulnerable. Ang karamihan po ng mga kaso natin, especially the big cases of corruption, of course, the witnesses there will always be in danger.
Yes.
What happens is, when they're in danger, they will spend maybe 5 years, 10 years in a safe house, waiting for their case to get to trial. In the meantime, yung mga akusado are out roaming around.
Yeah.
So, of course, naturally, they lose their interest, and many of those cases never get pursued. An amendment of the rules of court to allow for perpetuation of prosecution witnesses, whistleblowers, and others in danger, I think would be a very good development as far as the issue of accountability is concerned. As far as flip-flopping, well, I'm sure everyone in this room is aware of the dangers and why we should not stop, why we should not have this practice. Legally, it is a violation of the doctrine of immutability of judgments. And that doctrine is the bedrock of any legal system. Because the moment that any judgment that's final can be reopened, then really people will lose faith. Hindi na po talaga maniniwala ang tao sa sistema. As far as the faster and cheaper justice is concerned, I would have several proposals to address that. First, of course, I mentioned earlier, we should fill the vacancies in the trial courts. Second, we should require lower court judges to make specific evidentiary rulings. Third, I would revisit the rules on court fees and pauper litigants. I know that under the Algura case, the Supreme Court now says you don't have to strictly apply Rule 141. You can apply Section 3 of Rule 3, which is a more liberal standard. But still, some of our trial courts are still applying Rule 141. And I would want them to be aware that there is a better standard, perhaps, that should be applied. And finally, well, I would also push for the increase of the appropriations for the judiciary, because it's not only judges, but it's all the court personnel who need a lot of assistance, perhaps, so that we will be able to have that kind of independence that is needed for a judiciary.
Okay. That is a very interesting points which you have raised.
Thank you.
Now, insiders in the judiciary are saying that the appointment of an outsider as Chief Justice will cause demoralization within the ranks of the career judges and justices. Do you want to comment on that?
From a purely objective point of view, I would say that is really something that's within the prerogative of the President, given our constitutional framework. And it is something that I think we should not tie the hands of the President as far as that decision is concerned. After all, he is the one we have elected to run this country, and we should we also respect his judgment.
So, if that happens and you will be appointed as the next Chief Justice, how are you going to address that problem of demoralization within the ranks of the career justices and judges?
I'm not so sure po that that would be the necessary result, that there would be demoralization. There have been previous instances, I believe, in our judicial history where justices have been appointed from the outside. And although there is, I'm sure in the beginning, there will be a lot of adjustments and resistance, over time, I am confident that that can be overcome.
I see. Okay. During the impeachment trial of the former Chief Justice, the issue on the moral fitness of the Chief Justice came out. Can you tell us your perception of moral fitness as a criteria in selecting a Chief Justice?
I think, Your Honor, a Chief Justice must be something like a monk in terms of his life. If you would look at the rules of judicial ethics, there are so many social activities that are not exactly encouraged from members of the bench. And these are the kinds of activities that would put judges or justices in contact with potential litigants and actual litigants. And to me, that kind, I'm happy to say that I do not have that kind of a lifestyle. Hindi naman po ako mahilig sa mga ganyan. Actually, I would rather stay at home, read a book, watch TV, and study my law rather than go out. I don't even play golf. So as far as that's concerned, I don't think there's any problems.
So, if you will be appointed as the next Chief Justice, how do you want to be remembered?
I'd like to be remembered as someone who was able to improve the system for the majority of the public, for the majority of the people. Someone who can say that we can truly, genuinely deliver justice to the people. Right now po, law and justice are two separate concepts for the poor. For many of our poor, they identify the law with naked power. And they see justice as just a dream, something that they can never attain in their lifetime. And I would like, at the end, if ever I can leave a legacy, to say that I have brought justice back into law.
Okay. On that point, Mr. Chair, I have no more question for Dean Jokno. Thank you very much.
Thank you, Your Honor.
Justice Hermosissima.
Good afternoon, Dean.
Good afternoon, Justice.
I can see that you are as eloquent as your father.
Thank you, po.
You see, the tremendous inherent power in the hands of the Chief Justice and the Associate Justice of the Supreme Court require that those appointed to the position should possess the highest degree of competence, integrity, and judicial prudence. Because the administration of justice is a sacred task, entrusted only to individuals with the highest degree of competence. A judicial post is a position of honor and is offered only to those who are best qualified. Considering this, if you are appointed Chief Justice of the Supreme Court of the Philippines, what would be your judicial philosophy?
I like to think of myself, Your Honor, as a liberal, but I would qualify that a liberal who is imbued with a philosophy that respects human rights. For me, that would have to be the bedrock of everything I do as a lawyer and even as a person. So in terms of philosophy, of course, there are what they call the loose constructionists and the strict constructionists. You have those who believe in the Constitution as a living document rather than the opposite. In all of those, and those who would call themselves a judicial activist rather than a judicial conservative, someone who's very conservative, I would say I'm more on the judicial activist side, although not on that extreme. I would probably be more inclined towards a loose interpretation of the Constitution, and I would look at the Constitution as a living document.
The problem is there is no strict interpretation of what human rights are.
Yes, Your Honor, but the basis of all human rights is universal, and these are principles that apply to any person in any country, regardless of his birth, origin, background, family, relations, or anything like that. And I would like to think that even in our country, because we have incorporated international law as part of the law of the land, that all our courts are obligated to respect, protect, and promote human rights.
Do you not adhere to the resolution of the United Nations as to human rights?
The Universal Declaration, of
Yes.
course, Your Honor, as well as the International Covenant, civil and political rights, economic, social, and cultural rights. Yes, sir.
Does this mean to say that you are more inclined to favor the accused rather than the offended parties?
No, Your Honor, because you will find victims of oppression and human rights both on the side of the accused and on the side of the prosecution. The prosecution as well promotes the human rights by prosecuting those who violate the human rights of others. So I think, Your Honor, it would cut both ways.
Do you agree with the motto of the Integrated Bar of the Philippines, which says, "No master but law, no guide but conscience, no aim but justice"?
Yes, I think that's a good motto, although I have my own personal motto, which I inherited from my father. This comes from Carl Llewellyn, where he said that technique without ideals is a menace. Ideals without technique are a mess. One must apply both technique and ideals with vision. And to me, that would be my mission as a lawyer and as a
Well,
jurist.
there is no mention of justice in that motto. What then is your concept of justice, Dean?
Well, my concept of justice...
Of course, I'm warning you that, was it Disraeli who said that if you define justice, you limit it. And
Yes, Your Honor.
if you limit it, you destroy it. Anyway, Chief Justice Laurel has already defined what is social justice. What is your concept of justice?
My concept of justice is something concrete, something that the people can see happening in reality, not just a lofty ideal, not just something we strive for endlessly without ever experiencing it, but something that they can feel in their hands, that they have been aggrieved, therefore they have managed to get justice from the courts. To me, that would be the greatest legacy that anyone, in particular, could leave with the court.
As a magistrate, Jean, you decide cases on the basis of law.
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
Based on the facts, considering the facts in a certain case and the law involved. Now, considering the motto of the Integrated Bar of the Philippines, if the law is not in accordance with your conscience, will you abide by the law?
As a judge, I would have no choice but to abide by the law. But of course, how I would interpret the law would have to depend on what is available to me in that particular case. If I feel that, as provided in our rules and in our law, when a judge feels that the law he is applying is unjust, is unfair, then he can do everything he can to appeal to the proper body to repeal that law.
If the law is not in accordance with your concept of justice, will you abide by the law?
It's very difficult to answer that point in the abstract. In fact, it's hard for me to conceive of a situation like that, except perhaps if it comes from if it's a corrupt order. Then if it's a corrupt order, then I think that that's not an order that ought to be abided by, Your Honor.
Dean, when you enter the portals of the Supreme Court, of the United States, you can see emblazoned there the words equality under law. Perhaps a revelation of the court's judicial philosophy. Here, in the Supreme Court of the Philippines, what do you have? Batas, bayan. No, so in short, what can be your judicial philosophy?
My judicial
If you
philosophy.
have to, if you have these phrases as a paragon.
My judicial philosophy, Your Honor, as I said earlier, would be to concentrate on delivery of justice, especially to the masses who comprise our population, finding all the different ways and means that we can make justice real to them rather than just a dream, finding ways to give them more access to lawyers, finding ways to give them more access to the courts, because the sad truth is that many of our courts, it's just too expensive for many of our people to litigate cases, even cases that are very strong, cases that are meritorious but lack the proper resources on the part of the litigants. Very often they don't end up prospering because of the situation.
Dean, you've never been a magistrate before,
No, Your Honor.
not a judge, not a justice. Will you not find it difficult to go directly to the position of Chief Justice without passing through the Associate Justice or even RTC judges, MTC judges?
It will definitely be a challenge, but I would like to say that I have been going to court for more than 20 years, and from what I've seen, there have been some excellent justices who came straight from private practice. The beauty of it, Your Honor, is that I have seen how justice works firsthand at close range. I've seen it in the lowest of the lowest courts up to the highest of the highest courts. So I would like to bring that experience to the court if I can.
Well, that experience as an advocate, John,
Yes, Your Honor.
you can see that there's a whale of difference between your experience as an advocate and your experience as a magistrate.
Yes, there is a very big difference, and I would have to make sure that I will rid myself of the advocate's attitude if ever I am appointed to the court.
On that note, thank you very much.
Thank you, Justice.
Secretary Mosni.
Thank you, Mr. Chairman. I'd like to say first that I'm happy to know that the LaSalle program rests in your very good and capable hands.
Thank you.
Dean Jokno, do you consider yourself a religious person?
Perhaps spiritual might be closer to it, although I would not want to even claim to that term.
In that sense, do you think that religiosity or spirituality has a role to play in the dispensation and administration of justice?
Definitely, Your Honor. I think that it does. Because one's values really they spring not really from ourselves, but from something we see as higher than us. And when judges especially understand that they are not the highest law and that they must also bow to a higher law in the universe, then, of course, their decisions will be tempered.
All right. My next question is recognizing the present stage of our democratic space. Which do you prefer? Judicial activism or judicial restraint?
I think there is, at the present time, a need for more activism on the court.
Can you kindly explain
Yes.
further?
We are in a situation where we don't have yet a proper legal framework for the delivery of justice to the masses in our country. And for us to just sit back and take a more safe or conservative attitude, given that situation, I think would not benefit the people whom we are here to serve. I would say that as far as improvements in terms of the uplifting the minimum standards of people are concerned, labor and other sectors who are vulnerable in our country, then I would be inclined toward a judicial activism.
Who among the Chief Justices that we have had before do you think has left a judicial legacy that is worth emulating? What do you think would that legacy be?
One of the justices whom I really admire is Justice JBL Reyes. And if ever, I would like to emulate him, both as a man and both as a jurist. Up to now, I'm still very amazed when I read his decisions because hangang-hanga po ako as far as his judicial statesmanship are concerned. I'm sure there have been other good jurists as well, but it's also because perhaps I was able to meet him in person up close, and that's why I feel some affinity toward him.
Yes, thank you, Attorney Jokno. But is there any Chief Justice in mind that you have worth emulating with a legacy?
At the moment, Your Honor, I'm not sure I can think of any.
My last question, Mr. Chairman, is this. What is your position in this? Should the President be presumed to have residual powers other than those stated in the Constitution or specified in the Constitution?
Residual powers in what respect, sir, if I may ask?
Do you think that the provision allowing residual powers to be maintained and retained by the Office of the President is a correct concept in law in our time still?
If you're referring to what is contained in the revised administrative code, and if I'm not mistaken, what has been the subject of some legal debate, I think there is a danger in the exercise or in the use of that concept of residual powers, in the sense that, and I'm not referring to anyone in particular at present, but that may be or may tend to be abused. We are a highly regulated society. Most of everything that the President has to do is already provided either in the administrative code, in special laws, or in executive issuances. So I'm not sure really if there's a real need, except maybe in a very, very small class of cases. Areas where there is an obvious gap in the law and nothing beyond that, but simply for the President to act because there is no statutory regulation.
Thank you, Mr. Chairman. That will be all. Thank you very much.
Thank you, sir.
Perhaps the Honorable Frederick Musni refers to the late Chief Justice Fernand.
Now, just a few questions, Dean. You are a known advocate of human rights.
Yes, Your Honor.
You are likewise a defender of persons involving human rights.
Yes, Your Honor.
Now, you are aware of the rulemaking power of the Supreme Court?
Yes, sir.
For the protection of and enforcement of human rights?
The writ of amparo and the writ of habeas data.
In fact, that's the product. The product of that rulemaking power, or the products would be the writ of amparo and writ of habeas data.
And the rule on the environmental cases, Your Honor.
Okay. Now, my question is, you joined the Supreme Court as Chief Justice. Do you have rules in mind that you would like to introduce for the protection of human rights other than those that we have now, the writ of amparo and the writ of habeas data?
Well, before I would even get to that, Your Honor, I would first revisit the existing rules on the writ of amparo and habeas data and gather there have been a lot of inputs already from the practitioners as far as suggestions to improve those rules are concerned. If I'm not mistaken, even FLAG has submitted some proposals to the court. I think that the Chief Justice should look into that first, improve where it needs improvement, and when that is already working in a very good manner, at that point perhaps it would be good to look at further rules. At present, I think we have enough rules, Your Honor, to deal with our cases.
Yeah, I think you also submitted your suggestions for the possible incorporation of those rules
Yes,
in our
even-
existing rule. No?
Even the perpetuation of testimonies, we
Yeah,
have
okay.
submitted that, Your Honor.
Now, you were also talking about there is no need to amend the rules. Did I get you right? In order to expedite the termination of cases, there is no need to amend the rule except the some rules on evidence.
I believe my answer was there's no need to issue new rules. However,
Yeah.
with respect to the existing procedures in court, there are a number of changes I would like to see.
And then particularly, you were referring to the admissibility of evidence.
Yes, Your Honor.
So you are suggesting an amendment or probably amendment to the rules on evidence.
But perhaps not even an amendment, simply a directive or a circular to trial judges to make specific evidentiary rulings when offers of evidence are made. Because the problem, Your Honor, is many of our courts or lower judges, in my experience at least, in criminal cases, they will wait until the end of the case. Then they will decide on the outcome. Is this person guilty or not? If they believe he's guilty, then they will make the evidence, they will make the ruling on the evidence consistent with the outcome that they desire. Now, if we require the judges to rule on the evidence at the middle of the trial, then everyone, even the judge, will be bound by that in resolving in deciding the case at the end.
But in that particular case, if the evidence is not offered, then there's no evidence to admit, and the offer is only made at the time the prosecution or the accused rests its
Yes.
case. So probably the court cannot rule on the admissibility of evidence during the trial because there is nothing yet to rule on because there is no yet offer.
Well, when the offer
Probably
is,
what you're talking about is that we allow the suppression of evidence even before
that
the
is
prosecution
another,
rests. I think
yes.
that's what you're saying.
That is another proposal, Your Honor.
So you are also agreeable to the suppression of evidence in the pre-trial proper.
There should be a pretrial motion which allows the judge to rule on evidentiary issues, for example, that involve
Without-
constitutional matters, Your Honor.
So without waiting for the offer of that evidence.
Yes.
I think that can be done during pre-trial.
That can be done during pretrial. It's as a practice, however, it is not employed by.
Do you agree
any
that
of
the
lawyers.
pre-trial, therefore, is a good rule because it actually helps the early disposition of the case in pre-trial?
Yes, especially, Your Honor, if the pretrial is managed very well by the trial judge, then it becomes an excellent tool for facilitating the case.
So it's a question of who is the judge presiding in that court, not a question of the rules actually.
Well, it's a question, Your Honor, as well of the skill and expertise of the judge. As I recall, when I appeared in the Sandigan Bayan before the late Justice Garchitorena, when we would conduct pretrial, alam na alam po niya yung kaso. He had read the record fully well so that pag nambobola po yung abogado at sabihin niya ayaw niyang aminin, sinasabihan siya ni Justice, paano mo hindi mo aaminin yan? Sa preliminary investigation, inamin mo na yan. The problem with other courts where I have appeared is that the judges are not as active in understanding the record and in making sure that the parties will stipulate the facts that should really be admitted already.
Noong panahon ni Justice Hermosissima, ganun din stricto rin sa pre-trial Sandigan Si Justice Bobby Lagman, the husband of Justice Aring Lagman, ganun din, stricto rin sa pre-trial Ganun din sa akin when I was presiding
Yes,
Now,
Your
the
Honor.
other question that I would like to ask is, of course, you are against the reimposition of the penalty of death. You are also the view that it is not a deterrent to the commission of heinous crimes. Now, as Chief Justice, if you are appointed Chief Justice, what rules would you like to introduce in order to deter the commission of heinous crimes? Because you are against the imposition of the death penalty and it's not a deterrent. Can you think of something, a rule that would be promulgated by the court?
I think the problem really
Again,
is...
under the rule-making power of the court?
In order to address that issue, Your Honor, I would want to make sure that the courts can deliver justice, meaning that they are capable of deciding these cases in a manner that is swift and yet fair. And I don't think any special or particular rules will be necessary except to ensure that the courts do their job.
Now, you were also saying that judgment is already final and executory. You were saying that accused who are already convicted by final judgment, they do not actually serve their sentences in the national penitentiary. Did I get you right?
There is
you
a-
were quoting
yes, Your Honor.
you're quoting a data. Is that the fault of the court?
No, Your Honor, I'm not
it's not-
saying
it's
it's
not
the
the
fault
fault
of the court. I'm just saying that it is a problem that everyone
Must be addressed.
should address.
Must be addressed. I think the problem there is that these accused are entitled to bail even pending appeal, because these offenses, like the anti-graft, you were referring cases before the Sandigan Bayan, there are only a few cases that are non-bailable. Probably plunder. I think that's the only crime under the anti-graft that is where bail is not a matter of right. All the other cases that are filed against government official are all bailable.
Kasi mababa
So if the
po ang
cases
penalty.
are reached the Supreme Court and the accused is out on bail, and when judgment comes, and then a warrant of arrest is issued, that accused can no longer be found.
Yes.
So that's not the concern of the court. It is rather the concern of the executive, because their duty is to arrest fugitives. Is it not?
Directly po, it's not a concern of the court, but indirectly it concerns accountability. And I think that that's a concern of every member of the government, whether judicial or executive.
I was
or
also
legislative.
listening to you about cheaper justice, no? Cheaper justice. Is it your view that the fees being collected by the court are exorbitant
No, Your Honor.
and therefore beyond the reach of poor litigants?
My view is that we should look at the rule on pauper litigants and make sure that all trial judges understand now that the rule is you don't need to strictly apply Rule 141 as long as they can comply with Rule 3, Section 3.
Yeah, I had to tell you that because some of the fees that come from Rule 141, no? The fees that we collect actually are fees that are allowed under Rule 141 of the Rules of Court. And the fees that are collected are part of what we call the Judiciary Development Fund, or
Yes,
JDF, no?
JDF.
Which is a law, which is actually a law. The other fees collected go to what we call the SADS under RA 9227.
Yes.
All these funds are distributed to the employees. The JDF is on a pro rata basis. The lowest ranking employee of the court will get a higher allowance than the justices of the Supreme Court. The SADS allowance is an allowance to augment whatever judges receive from the GAA or the Appropriation Act.
Yes.
So if you reduce the fees that are collected you can just imagine what will happen to the employees who are already enjoying these allowances. Now you were also talking about flip-flopping decisions. What do you understand by flip-flopping decisions?
Well, my understanding, Your Honor, is cases that are already final in nature,
Oh,
where judgment has become final and executory.
But when a decision is rendered and it is reversed by virtue of a motion for reconsideration, that is not flip-flopping.
Hindi pa po, dahil
Hindi
the
pa, oh.
judgment is not yet final.
And if that case, again, is the subject matter of a motion for reconsideration, because the winning party will now become the losing party in a motion for reconsideration, and the court will reconsider its decision, that is not also flip-flopping.
No, Your Honor, that's
Yeah.
not.
Yeah, so that so that the public may know what is actually flip-flopping. Your definition of a flip-flopping is that if a judgment has already become final executory, then the court should no longer entertain any motion to revive that decision. That's what you're saying?
Yes, Your Honor.
But are you aware that even judgment of the lower courts may be the subject matter of a petition for relief from judgment, although the judgment have already become final executory? Or are you aware of a petition in the rules of court, a petition to annul a judgment due to fraud, extrinsic
Yes,
fraud?
Your Honor. Yes, that is
So why do you
recognized.
why do you
yes.
prevent then the Supreme Court from re-examining a decision that they have already rendered, which has already become final executory, when the Court of Appeals and when the Court of Appeals can entertain a petition to annul a judgment?
Two reasons, Your Honor. First, because the Supreme Court is the highest court of the land, and the buck should stop with the Supreme Court. Second, Your Honor, I see the practice as very pernicious as far as the court is concerned, because it leaves a bad taste in the eyes of the public. It does not add to the credibility of the court. I would rather have a system where, right or wrong, a decision is final, judgment has already become final, the parties have exhausted all remedies to question that ruling, then let's leave it and move on.
Anyway, probably you can only cite few cases, no, where the Supreme Court entertained a motion to revive, no.
Yes, Your Honor.
So I think it's only 2 or 3. How many?
Several. I'm not
Yeah,
sure of the number,
I
Your
think
Honor.
only 2 or 3. There was a wrong notion that in that case of FASAP, the Supreme Court flip-flopped. That's not true. We have not yet decided the case actually. Probably you're referring to a case. So anyway, we agreed that when a motion for reconciliation is granted, then that's not flip-flopping, you know. Okay.
Yes, Your Honor.
Now you were also talking about the process of appointment of judges. Is it really a problem in the appointment of judges? Are you not satisfied with the process being conducted by the Judicial Bar Council? Then later on, nominations are nominees. The names of nominees are forwarded to the office of the President for appointment.
I'm not referring to the present Judicial and Bar Council, Your Honor, but I have heard, although I have no personal knowledge myself, of a lot of horror stories perhaps that came out from the previous administrations. And I think that perhaps that is what should be stopped.
So it is your contention that the JBC should be retained?
I think we should be looking towards the future and looking beyond the JBC. I think there are ways that of choosing judges that are much less political in nature and more democratic. I think we should allow other sectors of our society, not only members of the bar, to select the members of the judiciary.
So your suggestion that non-lawyers should be included in the choice of judges?
Palagi ko po dapat din.
Dapat, ano?
Opo.
Dapat. Pati farmer, pwede na maril mag-join, ano?
Well, everyone has a stake in the justice system, Your Honor, the poor as well as the rich.
Okay, sige, that's all? Yeah, you have other questions?
May one.
Go ahead, Justice
You're talking, Dean, you were talking of the great vacancies in the judiciary, in the lower courts, for example. The reason for this is in places like Sulu, Tawi-Tawi, Samar, and other places that are plagued by recalcitrant elements, there are no applicants. And then there is another thing. There are courts that are created by Congress in remote areas. And so these courts, in these courts, we do not nominate because there are no cases. So that's the problem. That's the reason for the big number of vacant courts. You see, when a congressman creates a court in his district, but it's in a remote place. That's an achievement on his part. But then he does not think that there are no cases in these remote areas. So think of the vacancies. As a matter of fact, we are recommending that these courts that are in remote places be brought to Manila and other urban cities like Cebu and these places.
Yes.
Because here in Metro Manila, for example, we need a lot of courts, more judges. But in these remote areas, that should be removed and placed here. When I was appointed to the Judicial and Bar Council, the vacancy was 19%. Now it's 27%. But those are the reasons for the great number of vacant courts.
Yes, Your Honor.
Thank you very much.
Okay, we are through. Dean Jokno, thank you for coming.
Thank you, Your Honor.
You're welcome. May we have the next candidate?
Your Honors, the next candidate to be interviewed is Solicitor General Francis H. Hardilesa.
You may take your seat. Solicitor General. Okay. Attorney Cayusa.
Mr. Chairman and the honorable members, may I be allowed a short 5-minute opening statement, Mr. Chairman?
It was started by Dean Bautista. That's why I limited him to 3 minutes. Can we, because it's already 3:30, we still have one candidate. Can you make it 3 minutes? Okay.
Yes, Your Honor.
Okay, go ahead.
Thank you, Mr. Chairman, Justice Peralta, and the honorable members of the Judicial and Bar Council. Good afternoon. Thank you for giving me this opportunity to make a short opening statement. The Supreme Court stands at the center of our constitutional system, a government under the rule of law. Under our tripartite form of government, the Supreme Court interprets with finality the Constitution and all the laws of the land. The Supreme Court, therefore, is the guardian of the rule of law. The rule of law is protected and enforced by the Supreme Court through its exercise of its power of judicial review. This is the power of the court to determine that all acts of government, including those of the executive and the Congress, do not transgress the rights of the people as enshrined in the Constitution. What is most fascinating about this power is how the court, even without a standing army, can enforce the law. It does so through well-reasoned judicial decisions that pass the tests of independence, fairness, integrity, and probity. To be worthy of respect, the Supreme Court must speak in a clear and compelling voice through every decision. And what is a judicial decision? It is a well-considered and well-reasoned conclusion arrived after hearing adversarial positions, to which is applied the test of logic and evidence, governed by the spirit and letter of the law. It is thus very crucial, as a commentator noted, that legal reasoning be, and I quote, marked by its own integrity, close quote. This built-in theory of integrity of every judicial decision is so essential, it becomes the law's, and I quote, internal accountability, close quote. I fully subscribe to this insight and embrace it as my philosophy about the role of the judiciary. Without that integrity and accountability, the rule of law will collapse. Thus, whether one is liberal or conservative, whether an activist or a proponent of self-restraint, at the end of the day, the rule of law requires and plainly means that decisions of the Supreme Court must be products of careful legal reasoning and accepted and understood as such by the people. Having said that, my vision for the judiciary is an independent, equal branch of government that earns the trust of the people as guardian of the rule of law. It dispenses fair, equal, and responsive justice. It lives by its core values of fairness, accountability, and independence. This vision will be my guiding faith in the formulation of reforms in 3 priority areas: reaffirmation of the rule of law, effective administration of justice, and accountability and transparency. Thank you, Mr. Chairman.
Attorney Cayosa?
Thank you, Justice Peralta. Good afternoon, Solicitor General Francis Ardilesa.
Good afternoon, ma'am.
We have seen you here before, the first time when you were being considered for the Supreme Court, but as an Associate Justice then, and for the offices of the Ombudsman and Deputy Ombudsman for Luzon. Now, since the time you assumed as Deputy Ombudsman, could you tell the Council what you have accomplished as Deputy Ombudsman for Luzon, which you feel prepared you for the position of Chief Justice?
Yes, ma'am. I spent 7 months in the office of the Deputy Ombudsman for Luzon. And before I left, 2 of the most important projects I had was to craft proposed office policies on, number 1, what we call the filtering of cases, and number 2, rules to govern the exercise of discretion of our officers. What was filtering of cases all about? We realized, ma'am, that in the office of the Ombudsman, it was swamped with so many cases, such that the priority governed by statute, which is to prioritize high-profile cases involving high government officials and large amounts of money, were not being attended to because cases big and small were just given the same attention. And so we attempted to put up what we call a filter system. One of the most nefarious practices in government agencies is parties and even lawyers do not anymore know how to appeal. For example, a litigant is not happy with the decision of a prosecutor or the decision of a labor arbiter or the decision of a register of deeds. Instead of appeal, many times they will go to the Ombudsman and craft an anti-graft complaint. This is so pervasive in the office of the Ombudsman that there are so many cases where even on first blush, a well-thinking officer will know that this should not go, if you may say, past first base. And so it was very important for us to have the so-called filter system. And so with the filter system, I placed a very responsible, high-ranking officer to be a permanent watch so that as the cases come, based on certain guidelines, we are able to throw out at an early stage cases which should not take the time and resources of the Ombudsman. I'm very happy that just before I left the Ombudsman, I was able to have a bureau to take care of this filtering system, and to the best of my knowledge, ma'am, it is now working.
Do you have statistics to show that this filtering system has actually been effective in reducing the docket?
I do not have the statistics on hand, ma'am, but it is anecdotal, and when I compare notes with my colleagues, they are happy that they are doing their share of filtering the cases.
If you were to translate what you did in the Office of the Ombudsman to the trial court setting, how would you do that?
I would venture that, again, the judges at the first, second level courts especially, with the proper training, should be probably a little bit more proactive to control the dockets by requiring the litigants to really come up with meritorious cases. I always go back to one of the rules of procedure that when an attorney signs a pleading, it is a certification by him, by that attorney under his oath, that there is merit in that claim. And too often, I think, probably many litigants and many lawyers are not very conscious of this. And with the help of the courts, with the help of the bar, we can have a system where many of the more cases without really merit should not tax the energies of our court. And one of my favorite themes, just like in the Ombudsman, is what I call, ma'am, abuse of process. Many litigants, again, and many lawyers just file many cases. And typically, again, in the trial courts, for example, disbarment cases, instead of going up on certiorari, again, litigants or lawyers will file disbarment, file anti-graft, and really this clog up the courts. When I was in the Ombudsman, I realized that if a government employee, a lowly one at that, has a pending Ombudsman case, that person cannot travel, cannot be promoted, cannot retire. And many of the cases should not have been brought there in the first place. There is always appeal. There is always certiorari. And I think there has been too much resort to remedies other than what is in good faith should be a remedy of a litigant or a member of the court.
After you had gone through the Judicial and Bar Council process for the offices of Ombudsman and Deputy Ombudsman for Luzon, you were quite surprised that you actually accepted to be appointed to the Office of the Solicitor General. What made you accept that position?
The Office of the Deputy Ombudsman, Madam, yes, it is true, has a 7-year tenure. And to be candid, I was just one of the deputies. I was not the head. The Office of the Solicitor General, though it is not with tenure, to me offered a different set of challenges. The ability to be able to stand up before the Supreme Court and say, I represent the government, is a professional challenge, and to me a blessing that is hard to pass. And so on balance, when that position was open, the opportunity, as I said, to craft arguments on behalf of the government tilted the balance in favor of accepting. And I have no regrets, ma'am. I find the work, with all due respect to my successor in the Ombudsman, I find the work very, very professionally satisfying.
Thank you, Soljen. I just noted, as I was looking at your record and the record of Secretary De Lima, that you have actually been, in your legal careers, you have been associated with each other. She was a law clerk in your office, I understand.
Yes, ma'am.
And then now she is the Secretary of Justice, and you as Solicitor General are under her supervision.
Yes, ma'am.
So now that you are in the Solgen, what have you done to improve how cases are also being handled at the office?
The most important element that I think I have introduced into the Office of the Solicitor General is when I came in, they have a system of assignment of cases based essentially on seniority. There are task forces based on the seniority of the Assistant Solicitor General. I pay deep respect for the task forces, and I have told this to my Assistant Solicitor Generals. It is a testament to their seniority. On the other hand, I found a need to balance training for the younger ASGs, the younger lawyers now in the Office of the Solicitor General. And I am very proud that I have started to put the matter or the issue on the table. I am engaging my ASGs in a conversation about how we can essentially open up opportunities for the younger lawyers, at the same time, without disturbing too much the status quo. So this is a very professionally satisfying work, because when I get to the objective of making the assignment of cases more spread, and giving everybody the more opportunity, that will be a signal achievement, I think, on my part, Madam.
So in both offices, you have managed to do something about case management, handling of cases, and also professionalism of the workers in the offices. Now, I would like to know your thoughts with respect to not only accountability but also independence of the court, because I think that is one of the major issues facing the judicial system, is that many people feel that there is so much corruption in the lower courts or in the courts in general. How do you feel about, and what would be your policy with respect to judges or even justices receiving allowances from the local government units? Do you believe that this should be stopped so that they can maintain their independence?
I have a similar issue in the office of the OSG, because there are also allowances from agencies. My thoughts, Madam, are that probably there's a middle way, because indeed additional income to government employees, wherever they are, OSG or the courts, is a welcome development. It is in the distribution of the allowances. So probably in the OSG, we have put on the table the matter of giving the allowances as a pot, or into the pot, so that there is no ascribed person or ASG involved. In this way, it would be an institutional, or it is an constitutional contribution, if you may, of a government agency, or of, in the case of probably our judges, the LGUs, so that we do not attribute the extra allowance as to go personally to a particular judge, so that that particular judge will feel a debt of political gratitude to the occupants of the local government, Madam.
Would you set a ceiling to how much they may accept?
Probably, because again, we, just like in the OSG, we have issues with the COA. We have existing regulations, basically, I think, if I'm not mistaken, not more than 50% of base pay. Again, if this is in the judiciary, probably we will have to be very sensitive about how the other fellow employees in the government would be, and do it within bounds. I don't know the exact parameters, but it is something that is, extra income is always welcome, but not to be perceived by the people as something in excess, Madam.
Thank you, Mr. Solicitor General. I wish you luck.
Thank you, ma'am.
Justice. I have no further questions.
Attorney Mejia.
Thank you, Justice Peralta. Good afternoon, Soljan Hardeleza.
Good afternoon, sir.
Tinitingnan ko po yung mga comments kanina. Naalala ko na naman yung request na gumamit ng Tagalog. So siguro Tagalog-English po yung paraan ng pagtatanong ko sa inyo, if you don't mind. Nakita ko rin po marami kayong kasama rito galing sa Solicitor General's Office. Parang marami pong malulungkot kapag na-appoint kayo na Chief Justice. Tumatawa sila. This will be your third transfer, if at all po, because you were appointed as Deputy Ombudsman and then as Solicitor General. How do you think your quick transfer has made an impact on the office that you left or you will be leaving?
I would like to think, sir, that I spent 7 months at the office of the Ombudsman. As I have explained briefly, every moment of it, I try to do my best. And as I have said, I am very proud that I started some new things there on filtering. And for a lawyer to work with other lawyers, the opportunity to touch the lives of other people is always so satisfying. And in the process, you also get to know them and you are made a better person. So my 7 months in the Ombudsman has made me a better person, and I believe has prepared me. I think even as I had left the institution, I had given some contribution. I could have done more. And it is the same feeling that I have at the OSG. It is a great institution, great lawyers. I am surprised by the quality of the lawyers now. We have, I can say honestly, we probably can match the quality of the hiring of the private big firms. I try to manage by consensus, and I've learned so much about dealing this time with peers, especially my ASGs. But if I get onto a higher calling, again, I will be so lucky that I have touched lives, and similarly, they would have prepared me to be a better person.
Halimbawa po, nahirang na kayo bilang Chief Justice and it's your first opportunity to talk to the other members of the Supreme Court. What will you be telling them in that first meeting?
Kung pala rin po, the first thing I will do will be to probably call all the members of the court and have a conversation about how blessed I would be to be with them. Very conscious that many of them are older than me. Very conscious that I have never been a judge, and assuring them that kung pala rin po, I will do my work with all humility, learn from them, just like in the other 2 government offices where I have been and I'm now. I come in to learn. I have things to bring to the table from the private sector, but I will fully adjust myself.
Meron pong katanungan dito na gusto kong basahin na nakapatungkol sa inyo. Gusto lang naming malaman at itanong ninyo regarding the legality of the 3% Judicial Development Fund and Supreme Court Salary Adjustment Fund being imposed and collected by the RTC Clerk of Court mula sa na-foreclose na mortgage as a requirement na kailangang bayaran muna bago ma-annotate sa TCT ang foreclosure sale. Can we have your comment on that po?
Well, I will have to confess, sir, I'm not very familiar with that procedure, so I will confess I cannot answer you po.
Okay. With regards to the asset disclosure po of public officials, do you think there is a conflict between the secrecy provisions of the FCDL and the asset disclosure provisions of RA 6713?
My own personal view, sir, is that there is none. My view is that, this is my own personal view, is that this is one of the provisions of the Constitution, which in my view is self-executing. Of course, if confronted, if I sit in the court as a judge, I will keep an open mind, and despite my personal view, will have to decide the case based on the facts and the law.
As my final question, what should be the ideal relationship between a justice appointee and the appointing power?
The proper relationship, sir, is the relationship which springs out of our tripartite system of government, which is we have three co-equal branches of government. Once the appointing power has made an appointment, the appointing power should respect the fulfillment of the duties of the appointee, for example, in the judiciary. And likewise, under our separation of powers, whilst the Supreme Court has the power of judicial review, where an act of the appointing power or even of the Congress is at issue, under our system of government, due deference is always given to the powers of the executive within his realm, with the policy making of the Congress. But at the end of the day, it is the duty of the court, as is said in the Constitution, that where there is a conflict between the Constitution and acts of either the executive or acts of the Congress, then it is the bounden duty of the court to enforce the rule of law and, if need be, to reverse. But then many rulings of the Supreme Court coming back from Chief Justice Laurel always say the separation of powers is not supposed to be an ironclad separation of the three branches of the government. They are supposed to balance each other. They are independent branches, and hopefully if there is mutual respect, that's why I say go back, the rule of law, as long as the Supreme Court makes decisions which are based on reason and well elaborated, the executive may not mind. They may disagree on the logic. They may disagree on the basis. But if they know that the decision is made with integrity, the internal integrity of the judgment, it is based on reason, we always can disagree. But if we grant good faith, at the end of the day, sir, I think that's the proper relationship between the appointing power and the appointed in the judiciary.
Thank you. That will be all. Good luck, Solicitor General Hardilesa. Thank you, Justice Peralta.
Thank you, sir.
Justice Lagman is next.
Thank you very much, Mr. Chair. Sol General Hardilesa, good afternoon.
Good afternoon, ma'am.
Now, a Chief Justice is both a jurist and a Chief Executive Officer of the judiciary. As a jurist, he is expected to be not only be actually independent, but must be perceived as independent at all times. While as a CEO of the court, he has to deal with officials of the other two branches of government. If he will be appointed as the next Chief Justice, how can you maintain a cordial relationship with the other two branches of government and at the same time preserve your independence as a jurist?
That will be a very, that is a challenge, Your Honor, that I think I am willing to take. And I go back again, the role of the court is a passive one, as they say. The court waits for cases. The court does not make policy. The court does not enforce the laws. Mm-hmm. So for as long as the court keeps to its power, keeps to the limits of its duty, then it can coexist with the other branches of government. And it does need the other branches of the government. It needs the Congress, for example, when it needs to demarcate allocation of the judicial branches. It needs the executive when, for budget purposes, it needs funds for its infrastructure. And so I go back that if the courts stay to their duty, which is to decide only when there are cases, and decide well, By this, ma'am, I mean always by the use of reason. If the decision are using reason, and the citizen, the non-lawyers reading the decisions are convinced that there is logic, that there is integrity in the decision. You know, sometimes in a democracy, people will disagree. But as long as the court has the integrity of its decision-making process, from time to time it may disagree with the executive. But I believe that at the end of the day, when the Supreme Court stands for the rule of the law, it will be able to have a long-lasting, coexistent relationship with the other branches of government.
Thank you. Now, let's go to another point. The use of the Judiciary Development Fund as well as the special allowance for the judiciary has been criticized because of its alleged lack of transparency. Do you think that criticism is valid?
I think, ma'am, that to the extent that I agree with you, there is that criticism, and I feel it is a widespread criticism, and that's why I believe in transparency. These are public funds, and I think the people ought to know that the funds are used in accordance with what the law decrees, and appropriate disclosure, appropriate accountability should be made, just like any other branch of government. The judiciary, just like the executive, just like the legislative, we have all to account for funds. And so to me, the surest way to meet these criticisms is to have transparency.
So, if you will be the Chief Justice, you will also open those accounts for scrutiny by the Commission on Audit.
Yes, madam, as they should be.
Okay. Thank you very much. Now, again, if you will be fortunate to be nominated and appointed as the next Chief Justice, how are you going to bring the Supreme Court closer to the people?
Again, I go back, ma'am, to my theme that the best way for the Supreme Court to bring itself near the people is to have its decisions perceived to be fair and well-reasoned. But that's as a general rule. I think on a specific level, there are many, many programs. I know that many justices and past Chief Justices have embarked. We have the Judiciary Reform Program, Justice on Wheels. Yeah. All of these programs, to the best of my ability, I will continue. All these good programs bringing, that will bring the court nearer to the people.
This Justice on Wheels, do you think it helps in declogging the dockets of the court?
It helps, ma'am, but I think it helps. To what extent, I do not know. Probably the declogging of the court's dockets will have to be addressed by measures more than just justice of wheels. Principally, my thoughts would be first to get an inventory, and just like what the Court of Appeals has done, and I have had the good fortune of presiding justice and Andy Reyes show me around. They have a very good computerized system, and I think that will go a long way into declogging our court system.
Okay. Now, of all the members of the court, the Chief Justice is considered as the first among equals, primus inter pares. But to lead the court or the whole judiciary, you must do it with moral ascendancy. So how do you intend to gain the respect, the trust, and the confidence of the other incumbent associate justices, some of whom are older than you and who are more experienced than you, for you to effectively lead the judiciary?
My winning way is always, Madam, wherever I go, is to approach my new colleagues with just one formula: humility. Just be humble, go talk to them, know that they are there way before you. But if I am blessed by this Judicial Council to be shortlisted, and if I am blessed to be appointed, I will talk to my colleagues and say, with all humility, I am here, I would like to work with you, and please give me the chance to work and lead you.
Okay. Now, Soljan Ardelesa, this is my last question. How do you want to be remembered as the Chief Justice of the Supreme Court?
I will not venture, ma'am, from the question when asked in the Philippine Bar Association, how will I be remembered as a Solicitor General? I will have the same answer. I would like to be remembered as Chief Justice. And the one word that I would like to describe me is that Chief Justice exhibited rectitude. Rectitude, which is, being judicious, being even-tempered. That will be the capping glory of my career, Madam.
Okay. On that note, I have no more question for Soljan Ardelesa. Good luck, Soljan.
Justice.
Thank you, ma'am.
Yes, Justice Hermosissima, please.
Good afternoon.
Good afternoon, Justice.
We have interviewed you quite lengthily before, and it seems that you have passed the interview in flying colors, considering your intellectual background. Well, anyway, let me repeat that the tremendous inherent power in the hands of the Chief Justice of the Supreme Court require that those appointed to the position should possess the highest degree of competence, integrity, and judicial prudence, because the administration of justice is a sacred task, entrusted only to individuals with the highest degree of competence. A judicial post is a position of honor and is offered only to those who are best qualified. Considering this, if you are appointed Chief Justice of the Supreme Court of the Philippines, what would be your judicial philosophy?
My judicial philosophy, Your Honor, Mr. Justice, is one based on the rule of law. That given that the primary function of the Supreme Court is to be the guardian of the rule of law, that the court should lead by example, and considering that in deciding cases, the Supreme Court decides only through written decisions, the premium of the court should be that they write what I call well-reasoned and well-elaborated decisions, because from there springs the power of the court, Your Honor.
I wonder if you're aware of the Coco Levy Fund. Are you Does that ring a bell?
Yes, Justice, from what I read from the papers.
Oh. Well, there's involved billions of pesos in sequestered assets coming from the Coco Levy Fund. And this was acquired with the tax on copra collected from farmers for 9 years during the Ferdinand Marcos martial law. Are you aware of what happened to this coconut levy fund? Billions of pesos intended for the benefit of coconut farmers and intended for the rehabilitation of the coconut industry.
I believe, Mr. Justice, that the Supreme Court has already ruled that the cocoa levy funds belong to the farmers. I believe there is a motion for reconsideration filed on that case by the Coco Fed, and in fact, the Office of the Solicitor General has opposed that motion, and that's as far as my knowledge will go, Mr. Justice.
You were not privy to the cases involving these funds?
No, Justice, I was never involved in any of those cases. That's why I say what I know of those cases is what I read from the papers. Until I became Solicitor General, when I had to read the decision because the Office of the Solicitor General is involved.
As the lawyer of the Honorable Danding Kuhuangco, you were not privy to these transactions?
No, Mr. Justice. I was the lawyer for San Miguel Corporation, and San Miguel Corporation was not involved in those cases. Mr. Kuhuangco prosecuted those cases on his own personal behalf, and he had his own personal lawyers.
Well, on that note, thank you very much. That will be all.
Thank you, Justice.
Attorney Secretary Mosngi.
Good afternoon, Soljan.
Afternoon, Secretary Musking.
Mr. Solicitor General, what is your opinion on the so-called seniority rule in the appointment of the next Chief Justice?
Well, the seniority, with all due respect, sir, the seniority rule is something I think left to the best judgment, first of this Honorable Council, and later on of the appointing power. But permit me to say a few thoughts. Being Solicitor General is a lofty position which brings me a little bit closer, perhaps, to the Supreme Court than other practitioners. The fact that the Solicitor General represents the government and its agencies before the Supreme Court, and the fact that the Solicitor General, by the words of the Supreme Court, is tribune of the people, and that the Solgen argues the cases of the government before the Supreme Court, brings the Solicitor General into a unique position, as one commentator has said, to be in a distinctive position to, on behalf of the government, engage the highest court of the land in a dialogue. They call it a Socratic dialogue in order to arrive at good decisions. So in that case, I am very blessed and very lucky to be in this position. And whilst, again, the question of insider versus outsider is something for this Honorable Council and for the appointing power, I will consider that a Solgen is somebody who is not inside but is not probably completely outside knowledge of the processes of the court.
Thank you, sir. Soljan, it was previously reported that during your interview for the position of ombudsman, you were asked if you would inhibit from cases involving San Miguel Corporation pending before the Supreme Court. You replied no, and correct me if I'm wrong. You replied no to this query and added that I am not sure if I need to inhibit at all because logically I will then have to inhibit in all cases that have to do with other law firms I work with. Will you maintain the same position if appointed as Chief Justice? And yes, that's my question first.
No, sir. I will not maintain that same position anymore.
Do you then believe that as Chief Justice, there would certainly be conflict of interest in the matter of pendency of certain very contentious and controversial cases at the Supreme Court level, a private party involving your former employer, the San Miguel Corporation?
If I am blessed to be Chief Justice, sir, I will inhibit from all cases involving San Miguel Corporation.
Thank you, sir.
Thank you, sir.
How do you understand the political question doctrine, Soljan? Do you think that this doctrine is still relevant under our times today, notwithstanding the power of judicial review expressly granted to the courts under Article 8, Section 1 of the Constitution?
Yes, sir. Whilst we have what we now call the expanded power of judicial review, or the duty of the court to determine in all cases whether there is grave abuse of discretion on the part of any branch or functionality of government, I believe personally that there is still room for true or real political questions. In a narrow set of cases, there will always be room for circumstances or facts where the court should not exercise its power of judicial review.
My last question, Mr. Chairman, is, Soljan, you characterize the judiciary as a passive institution that does not craft policies. Does the judiciary have a role in national development then, do you think?
Yes, sir.
I'm sorry. And does the judiciary precisely have a role as well in the upliftment of the quality of life for every Filipino?
Yes, sir. I think the judiciary, whilst it is a passive institution, when it is confronted with an actual case or controversy, has to make a decision. And therein lies the role, the big role of the judiciary in national development. For example, to the extent that we need foreign investments, one of the criticisms has been that our laws are interpreted not consistently, and to the extent that the court could speak with one voice, to the extent that the court could follow precedent, these are matters that will help invite, for example, foreign investments. And so the court, it is a natural body that believes in precedents. And national development, business, they are for maintaining credibility through predictability. And so there is a big, big role for the judiciary, sir.
It's my turn, Mr. Solicitor General. I have asked you some questions when you appeared before the court in defending the government. But the questions will now be different from the questions that we propound when you appear before us. No?
Yes, sir.
Now, you appear to be humble the way you answer the questions and the way you gesture in answering the questions. Am I right? You confirm that. You really appear to be humble.
I am humble, sir.
My question is, are you really humble?
Yes, sir.
Oh. My next question is, do you really know the work of a Chief Justice? Do you really know the work of a Chief Justice?
I do not know in the sense, Your Honor, that I have never been even a judge. But I think from what I have learned, from what I have read, from what I have observed, it is a very important job. But to answer your question, not of my personal knowledge, because I have not been even a judge.
Yeah. You know that during en banc sessions of the Supreme Court, where the Chief Justice is the presiding officer, you will have to tackle something like 300 cases. 300 cases on a single day for deliberation before the en banc. And you're the presiding officer, you're not aware of that?
No, Justice.
You're not also aware of a decision is submitted by a ponente. There are several opinions that are submitted, and then you are also aware. You should also be aware of the different opinions of the justices, because you will be the presiding officer. You do not know that?
Well, I am aware in the sense that, in fact, Justice, there are so many instances where there are different opinions.
Yeah, there are opinions, and the Chief Justice must be aware. He should know what are these opinions. Is it not?
Yes, Your Honor.
Then the Chief Justice likewise heads a lot of committees, and he should be on top of all these committees. He will be the presiding officer of the Judicial Bar Council. He will be the presiding officer of the Philippine Judicial Academy in its monthly meetings. He will be the presiding officer of the Mother Committee, which we call the Committee on the Revision of the Rules of Court. There are so many committees that the Chief Justice heads.
Yes, Your Honor.
And in fact, you are the chief administrator not only of the Supreme Court, but the whole judiciary.
Yes, Justice.
So do you think that you need sufficient experience in order to become an effective Chief Justice?
Well, my answer to that would be, Your Honor, that yes, experience is important, but with all due respect, not indispensable, because workloads, committees, can be met, and there are delegations.
No,
you can delegate work, but the primary challenge.
But you will have to be on top of all these committees, even if you delegate. Example of which is the preparation for the budget of the Supreme Court and Judiciary. You can delegate some of the justices, but you have to be on top of the preparation of the budget. That's only one of the functions of a Chief Justice. A Chief Justice does not sit there in his office and then call for the justices or the subordinate officials and do this and do this. Unlike in the executive, if you head a department, come out with an order or a memorandum, require all these people to do this and to do this, that's all. Everybody follows. Not in the Supreme Court. Are you aware of that?
Well, yes, Your Honor.
And the decision of the Supreme Court is always arrived at through deliberation, sometimes heated arguments. Yes.
Yes, Your Honor.
You're aware of that. So I believe that experience really plays an important role in order to become an effective Chief Justice. Do you agree?
Well, as I said, Your Honor, experience.
I'm not saying that you should withdraw from the nomination. What I'm saying is that this is what really happens. This is what really happens in the Supreme Court.
Again, my statement, Justice, will be certainly experience is important, but with all due respect, I think it is not indispensable.
Okay.
Because I have also had some measure of experience, for example, budgeting in the private sector. And when I went to the Ombudsman, I also to prepare the budget of of Luzon. I mean, it was not for everything. It was new, but I had to learn, and now we are in the budget process in the OSG. It is altogether new again, but I have to learn, and I with all humility, I believe I have coped. The magnitudes may be different, and certainly I do not say that experience is not important.
Okay. Now, you were asked about the coconut levy funds, no? And according to you, there is still a pending motion for reconsideration filed by COCOFED.
Yes, Your Honor.
You're representing the PCGG, I suppose.
Yes, Your Honor.
Are you participating in that motion, in the preparation of, or will you be signing the comment or the reply or the pleading that will be submitted by the Solicitor General?
I have signed, Your Honor.
So you will be participating.
Yes, Your Honor.
Is it not that the shares allegedly owned by Ambassador Cojuangco, which I think is equivalent to something like 20%, 20% of the total shares of the San Miguel Corporation, you were then a corporate secretary of San Miguel Corporation. You were a corporate secretary of San Miguel Corporation.
Yes, Your Honor.
Is it not that there were questions about the composition of the boards of directors in the board meetings of the San Miguel Corporation, and that at that time you were a corporate secretary of San Miguel, and therefore participated or interpreted probably, or gave an opinion that Mr. Cojuangco can still vote, and vote the 20 equivalent to the 20% shares of Mr. Cojuangco?
I remember I did. I was the corporate secretary at that time.
So in other words, you knew about the shares of Mr. Cojuangco.
Yes, sir, that he has these shares that he contests.
So anyway, there are actually two cases here involving the coconut levy funds. The 20% being claimed by Ambassador Cojuangco, which the court has already decided as his. Is it not?
Yes, Your Honor.
The other case is the 27% being claimed by the coconut farmers, which the Supreme Court declared as owned by the coconut farmers, but held in trust for the benefit of the coconut industry. That's the ruling. That is now the one that is pending reconsideration.
Yes, Your Honor.
Now, I ask this question because you are the Solicitor General. I will also ask the same question which I asked of Justice Secretary De Lima. No? Is there anything about your past or background which, if becomes public, would not only become a source of embarrassment, not only for you, but the entire judiciary?
No, sir.
Okay. Do you definitely, no?
No, sir.
Yeah, okay. You were talking about allowances. What is your position so far as allowances being received by judges from the cities or provinces where they are assigned or stationed? No? You said that. Did you say you had no objection? Because that is one way of augmenting their income.
If the income is given, I think, as a whole, then perhaps there would be no conflict, Your Honor. As I said, I'm basing it with the experience we have at the OSG. Government agencies will give allowances, and they will give allowances to a task force, so-called, and we are now in the process of having a conversation with the ASGs that perhaps to avoid issues of conflict, if an agency wants to give to the OSG, it should be as a whole.
But the situation is in the OSG is different, because in the OSG, you receive allowances from your clients, and that is allowed, I think, by the COA. But here, the members of the court or the lower courts, the judges from the lower courts receive allowance from the cities or provinces where they are assigned or stationed. So there may be a conflict of interest.
I will keep an open mind on that, Justice, because if it is given across the board, not to any person, but as a subsidy of the city, for example, to the justice system,
You will not have any objection.
on those facts, probably, I will keep an open mind.
So
There
you
will
will be a generous Chief Justice, probably.
well,
You will be a generous Chief Justice, probably. No?
if there will be LGUs who will give, Your Honor,
Oh, you will allow it. No?
will allow it.
Now there is a question from the public. I do not know if this is true. You were appointed 2 weeks after the Supreme Court decided in favor of the coconut farmers. Is that true? You were appointed as Solicitor General. Probably the question should have been, you were appointed Solicitor General 2 weeks after the Supreme Court came out with a decision favoring Mr. Cojuangco. I think that's the question. That should be the question.
I do not
You do not
know
recall.
the
Do
date.
not recall.
I took my oath as Solicitor General, Your Honor, February 10, and I think my appointment was signed 1 week before that.
But you were not yet the Solicitor General. It was still Solicitor General Cadiz when the decision of the Supreme Court came out. I think that's correct, no? You cannot remember.
I do not know, Your Honor.
Yeah. Now, you agree that the judiciary is the weakest among the three branches of government?
Yes, sir. That's
Yeah.
the received wisdom. It's the weakest.
In fact, the Supreme Court receives only, I think, less than 1%
Less than one, I think.
of the national budget.
Yes, Your Honor.
If the Chief Justice, can you do something in order to increase the budget of the judiciary, the Supreme Court, and the judiciary as a whole?
Well, Your Honor, I think the Supreme Court has been trying to reach even just 1%, and probably if the court will be in the interdependent terms with the other branches of government, we stand a chance of pleading the cause for a bigger budget.
Mm-hmm. And what would be your proposals in order that the Supreme Court will be equal to that of the two other branches of government in terms of probably power or authority? Because according to you, you agree that the judiciary is the weakest among the three branches of government.
Well, I think, Your Honor, the Supreme Court should keep to its role, which is just to decide cases, to make decisions in case of actual cases and controversy, because it is important for the court to keep to its mandate. The court, as I said, does not make policy or does not execute laws. But it's very powerful in the sense, for example, that it protects individual rights. It is very powerful. It makes law being sensitive to women, being sensitive to gender. It is in that sense very powerful because it can be one case, but one case can be so important that even if the court, as they say, is the least dangerous branch or the weakest branch, it can make also a big difference in its own way, Your Honor.
I had no more questions, Mr. Solicitor General. Okay, I think you are through.
Thank you, sirs and madams.
Thank you also for coming.
Your Honors, the last to be interviewed today will be Senior Vice President and Chief Legal Counsel Maria Carolina Legarda. She's from the GSIS.
Welcome. Good afternoon, too.
Good afternoon, Your Honors.
Okay. Attorney Cayusa?
Thank you, Mr. Chairman. Good afternoon, Attorney Legarda.
Good afternoon, ma'am.
May I just state for the record that Attorney Legarda and I have known each other since I served as a volunteer lawyer of the Child Justice League, of which she is founding chairperson. Well, I think the first question is, why do you want to become the Chief Justice?
Why do I want to become the Chief Justice? Well, it wasn't on the list of things I wanted to do as I was growing up. Being a lawyer was also not one of the things that I wanted to do growing up. But I realized after I was nominated, and I was nominated by so many people, I didn't want to let them down. And if they felt that I was competent and I could clean up the courts and I could manage and administer the ills of the courts, then I stand to be counted with everything that I have for the courts and for the litigate and for the lawyers who work with the courts.
Except for your very brief stint at the GSIS,
Yes.
I believe that you have been in the private practice of law all throughout your legal career. What is it in your past that you have accomplished which makes you feel that you are ready to be at the helm of the Supreme Court?
Yes, I have been in the private practice of law for 32 years. However, in that private practice of law, I put up the Child Justice League, which we organized and administered in order to ensure that children in conflict with the law and children who have been abused are properly assisted in courts, and that requires a lot of administration and management because we work with the DSWD and all that the government entails in sense of red tape. Despite however brief I was at the GSIS, I cleaned up the law department, organized it into like a law firm, put the lawyers in the places where they should be, found out their strengths and weaknesses, and therefore was able to give the Board of Trustees sort of go-to lawyers. These are the lawyers whom you should go to, let's say, for foreclosures, for contracts, for legal opinions. So I organized them into maybe 5 groups, 3 under litigation and 2 under advisory and legal opinions.
What is your vision for a Supreme Court under the Legarda administration?
Somebody once said very recently that the face of the judiciary is actually the person of the judge. The concept of judicial independence, that is extremely abstract for the ordinary person and even for the judges who join the judiciary. So what is it that people understand? Litigants, lawyers, judges. They understand the concept of fairness and impartiality. So when you go to court as a lawyer, and I was a very active practitioner for 32 years, I always know when the judge has rendered justice. Because even if I may lose, I feel that I was treated impartially by that judge. And that is what I think I can bring to the court, the concept of fairness and impartiality. So equity as it might impact on the rule of law.
As a result of the impeachment trial, the concept of justice to be had in our country has become rather remote in the sense that most sectors feel that there is corruption in the judiciary. How do you think you will be able to address that perception, and how would you turn it all around so that people will have faith in the judicial system?
Well, I think a lot of the problem of the corruption in the judiciary, and it is an outrage to me because I know that there are honest judges. I know. I mean, 2 of them are sitting here. 3. Justice Peralta. Sorry, Justice. 3 of them are sitting here. I know that they are honest judges. So it is an outrage to me that there is this sweeping condemnation of the judiciary as being corrupt as a whole. And I think a lot of this has to do with the frustration that people feel when they do go to court and then they file cases against judges and judicial personnel. And it takes so long. So not only do they have to keep facing these judges and judicial personnel because it's taken 5, 7, 10 years for a case to be disposed of, either by the Office of the Court Administrator or even by the Supreme Court, depending on what the case is all about. And there is justice delayed and justice denied, and frustration festers. And worse, the ordinary Filipino, he doesn't understand that the lawyer does not want to go to court against the judge because he knows that he's going to be facing that same judge for his other clients. So it's a wheel, it's a never-ending wheel of frustration which sets in. So I think probably the first thing I will do is to reorganize the Office of the Court Administrator to facilitate and hasten the disposition of complaints against judges and court personnel. Make it fair to the personnel so that cases against them do not languish, thereby preventing their promotion to higher positions. And fair to the litigants, because at least when they go to court, they know that in a few months, this judge whom they are now facing may either be suspended or may be declared innocent of whatever heinousness was charged against him. So I think that's the first thing that needs to be done. When judges and court personnel know that the axe will fall, and it will fall quickly and exceedingly small, I think the concept of corruption may be addressed.
Perhaps it may help that you are able to monitor how the courts are doing, the lower courts are doing. What do you propose would be a good way of monitoring the performance of judges?
The problem right now with the way that judges are being evaluated is that all judges are evaluated under the same standards and criteria. So a family court judge, where some cases never end, support, visitation, these things never end. Custody. The family court judges are evaluated on exactly the same standards and criteria as a judge of another court, let's say environment, or let's say commercial courts, who do not have the same number of cases. So I think that monitoring them, I will probably suggest to the court that we change standards and criteria, monitor the caseload, perhaps think about asking if there is a constitutional amendment, perhaps think of asking them to return the constitutional provision that the Supreme Court need not give facts, issues, and the reason why you're dismissing the case in one. This takes a lot of time, when in fact many cases should never have even gone to the Supreme Court. So I'm sort of looking at something like the U.S. Supreme Court, where everyone knows that they will only handle X number of cases every year.
If you were to look back, was there something that you would have done otherwise, especially with respect to the promotion of children and women's rights?
Would I have done something otherwise? Maybe I would have earlier begged the Supreme Court to implement the Family Courts Act and stop the designation, which is still ongoing, of family court judges to the RTCs. RTCs. Up to now, they're just designated. So we have a lot of judges there who are just not interested in handling family cases because, well, they don't understand the psyche of the child, the family member going to court, the person who has to undergo the judicial system. So maybe so. But when we handled the prosecution of the former congressman rapist, there were still no family courts. When I was appointed by the Supreme Court as counsel de officio of a woman on death row, well, women in death row cases do not go to family courts. So this is something else I would ask, that there are some cases which perhaps should go to family courts and they should stop designating and actually appoint men and women who are interested in doing that kind of work. Because women cases do not go to family courts either. They go to the ordinary courts.
Thank you, Attorney Legarda. What is your opinion with respect to restorative justice? Do you think that we should limit the application of restorative justice to minors, or that we should expand its application?
I always understood the concept of restorative justice when we were helping students before, when I was a practitioner, when things happened. I always understood the concept of restorative justice to apply to all. That imprisonment and punishment was meant to be to assist the person return to the community. Unfortunately, I suppose it's a function of budget. Those who we bring into the court and the penal system and then incarcerate actually become even more criminalized in the prisons. Restorative justice, I think, is good because, especially if this is the first time you've done it. I mean, we're human beings. We all make mistakes. Kahit one mistake. The concept of restorative justice, I think, will bring back a lot of goodwill in the courts, especially when the ordinary man is picked up on the street because he is like Jalbert and he just stole a piece of bread to feed his child. If he can just return that bread or tell the person from whom he stole, my child is very hungry, I just needed this, I promise I cannot do this again, what can I do for you to help me restore my reputation? So restorative justice, I think, is for all, and I think particularly for those who cannot afford lawyers.
Would you go so far as to including in a judgment the requirement that the convicted rapist would have to undergo counseling?
Yes, not just counseling, but definitely not just counseling, but really extraordinary forensic therapy will be required for this convicted rapist. Right now, rapists stay in jail for the rest of their lives. There's not much restorative justice there. With respect to a child who cannot give consent, in my opinion, except that our criminal laws say that they can at the age of 12, I think a convicted rapist needs more than just counseling. He will need to undergo a lot of self-knowledge as to why this happened. And we don't have those trained to do that here.
Given my time limit, this will be my last question.
Yes,
in
ma'am.
your personal data sheet, you identified as one of your references Mr. Enrique Razon.
Yeah.
Could you explain why you put him as a reference, and what is your association with Mr. Razon?
Mr. Enrique Razon and I have actually known each other since he was a child because I was a good friend of his sister. So he has actually known me ever since he became an adult and I started working from then. I approached him on many occasions to help us with the Child Justice League and now with the Child Protection Network. We always need a lot of funds so that we can increase the number of lawyers that we have to help the child. And each time he has never, ever said no. And when we asked him to be on our board of trustees for the Child Protection Network, he said, although I'm not sure if I should take this on public TV, I cannot look at a child rapist in the eye. I might shoot him dead the next morning. So can I ask you to have my wife on our board? So we have his wife, Lizzie Razon, sitting on the board of trustees of the Child Protection Network Foundation, and both of them know how well I have administered and managed the needs that we have all around the country, not just in the Philippines, because we have child protection units also in Pakistan and in India, and how we help them administer and manage these units to help the child.
Thank you, Attorney Legarda, and good luck. Thank you, Justice.
Attorney Mejia.
Thank you, Justice Peralta. Good afternoon, Attorney Legarda.
Good afternoon, sir.
What is your greatest frustration as a lawyer?
Delay.
Delay.
Delay in the courts, yes. It is very frustrating, especially because the private litigant really does not understand why her or his case needs to be calendared only once a month.
Thank you. Should there be a gender perspective in deciding cases?
Well, there is substantial equality already between the woman and the man in the Constitution. There is gender perspective when it is appropriate, I suppose, like in the battered woman case, a child who may have come into conflict with the law or a child who has been sexually abused. But not all cases need a gender perspective, especially if crimes are applicable to all. Just because you're a woman or a man should not increase or decrease your penalty if you have committed an offense.
When you first learned that you will be required to submit a bank waiver, what was your reaction?
Okay lang, I have nothing to hide.
Okay. If you were in the position of Secretary de Lima, given that situation she confronted when, in the case of the departure of the first couple, how would you have dealt with the same situation?
Well, Secretary de Lima then dealt with it in a very political manner. She felt it was a decision which was based on politics, having been issued by people who had been appointed by the former president. So she treated it as a political issue and therefore rejected the decision, the order of the court. I'm not very political in that sense, and I actually don't look at justices as to who appointed them, because I find that once they have been appointed, most justices want their reputations to be preserved and not besmirched. They don't want to die knowing that their children's and their children's children do not respect them. So I probably would not have addressed it from a political point of view. Secondly, my understanding of the events, although I was at the time doing a project for the Philippine Women Judges Association, so I was actually in The Hague doing a final report for the MDG3 fund for the PWJA. My understanding was that Secretary de Lima was not actually a party to the case. And so she need not have been served a copy of the order. That's the understanding I have. And it was merely an order for addressed to the immigration with respect to the then president and first couple. So I probably would not have addressed it from a political point of view.
Is there any instance where you regretted a manner by which you handled a particular case in the past?
No. And I think it is because I treat people as fairly as possible. And in the last 12 years, I've been mostly in family law practice. And always my first concern are the children of this marriage, who did not choose to be born and who have no lawyer helping them. So I have always addressed cases from the point of view of those who are going to be the most affected and have no counsel to assist them, or no venue upon where they can vent their needs or concerns. So in the last 12 years, no, not really.
Thank you, Attorney Legarda. That will be all.
Thank you, sir.
Justice Peralta. Good luck.
Justice Lagman, please.
Thank you, Mr. Chair. Attorney Legarda, good afternoon.
Good afternoon, ma'am.
Now, in your opinion, did the impeachment of the former Chief Justice infringe on the judicial independence?
Yes, to a certain extent. Yes. Only because I felt that the grounds were not really impeachable offenses. Betrayal of public trust, not really. What they brought up against Corona, not really impeachable offenses. Although I did see how the prosecutors tried to weave this into a general sense of betrayal of public trust. No, I say yes also because the courts became scared that when they displease a higher authority, they will have problems in the future with respect to the decisions that they will come out with. I felt it impinged a little bit on judicial independence because the morale of the courts plunged. And many of the judges I work with and justices in all the trainings and work I do for the Philippine Judicial Academy, in the very beginning were like lost sheep. What's going to happen to us now? And how can we tell the people whose cases we are hearing that this is not what the judiciary is all about, what is being brought up in TV against the Chief Justice? So to that extent, yes.
Okay. Now, Attorney Legarda, what do you think is the advantage, if any, of having a lady like you sit as the Chief Justice?
A lady like me. I hope that I am able to persuade the present justices of the Supreme Court that I am not there to spy on them, nor am I there to report on any shenanigan that they may voluntarily or involuntarily find themselves in. I feel that the justices know that I have never approached any of them for any kind of favor. And I feel that my work is such that they know I'm a very hard worker. And I think that I will be able to talk to them and ask for their help to cooperate in what a Chief Justice's role is. The Chief Justice is only one vote in a group of 15. So there is no Chief Justice who can really influence how a particular decision will come out. The role of the Chief Justice is management and administration, with the office of the court administrator being like its implementing arm. The role of the Chief Justice is to find out what can we do to help the courts more, better working conditions, more access to the internet, more access to technology, improve the rules so that justice is not so delayed. So, motions like extensions of time and postponements and cancellations can just be done through the internet or Skype. Right now, justice is very expensive because I may have to go to Tuguegarao, for example, or Bacolod to find out somebody crucial is absent, because they will not accept. They will take to you, ay, attorney, tuloy yan. Yung pala, hindi tuloy. Pagdating mo doon, you've already spent for airfare, you've already spent for hotel, you've already spent for food, So I think if I were going to go there and be a young person there as a Chief Justice, I would probably have more energy, and having swept up, I think, and reorganized the GSIS legal department in a very short time, I think I have the energy to tell them, look, I cannot be as detailed and as wise and as deep in the handling of actual cases unless you give me a case to resolve. But give me the work of administering and helping you make life easier for the judges and for litigants. And I think I have the energy to do that. And it's something I actually enjoy doing. I actually enjoy putting things into order. It appeals to a sense of order that I have.
Okay. Some of the incumbent associate justices who are males are older than you. Mm-hmm. And they have been there for quite some time. How are you going to lead the court with the moral ascendancy?
The face of the Chief Justice is just the outward face of the judiciary.
Yes.
I think that the moral ascendancy of the Chief Justice is not necessarily among his co-equals on the High Court, but rather on those below the High Court. I cannot have moral ascendancy over persons who are equal to me if I was to be Chief Justice. But I can certainly ask them to cooperate, to help me rebuild this very tattered reputation that the judiciary has right now. And I think that all of them will be interested and be concerned in making the judiciary a truly co-equal branch of the government again. Right now, it's in tattered remains.
Okay. This is a question which we received from our Twitter and email at 4:50 this afternoon. Yes. This is a question for Attorney Legarda. Now, how do you respond to criticisms that family lawyers aggravate the enmity between married couples, causing further conflict?
Actually, I will agree about some family lawyers. Instead of trying to make things easier for the family to go to the court system, some of them really exacerbate the problem. I do agree, which is why when we were preparing the rules for the Supreme Court on mediation, we specifically requested, I specifically requested, and I think Judge Bison and then DCA Vilches specifically requested that lawyers not be allowed during mediation. Because they really exacerbate the problem.
Okay, so it's true.
So for many, yes. I hope it's not true for me. I hope it's not true for me, but for many, yes, I have seen it. I have seen it. They tend to needle their client. And in fact, very recently, a friend of mine who was handling a particularly contentious case was very upset because what the client of the other lawyer did was she went to a third lawyer, and filed something in court. Talk about lack of legal ethics that the third lawyer took it on, knowing that these two lawyers were already talking and about to enter into an agreement. So yes.
Okay. Now this is the second question. It's a fact that there are many juveniles who are engaged or involved in most of the crimes today. Is there a need to reform the laws on juvenile crime and delinquency?
First of all, I object to the premise that most of the crimes today are committed by juveniles. That is extremely not true. In fact, the statistics on juvenile delinquency have not changed. The problem is the investigation of crimes is so bad that it's easier for the police officer to grab a juvenile off the street and add it to the statistics of their crime. Solved, child picked up, change the law, because we cannot arrest a child who's below 15 or below. So I don't think, we need to implement the juvenile justice law. We need to persuade the local governments that they have to put money into their communities so that they can build separate facilities for the children in their communities who may commit offenses. We need to persuade the local governments that they need to invest money into training of the social workers and training of the police so that it's not true that you don't arrest a person who is 15 and below. You have to take them into custody and have them go through therapy. Otherwise, if you keep letting them go and say, hindi ko ma-arresta yon dahil below 15, by the time that boy or girl turns 18, he's a full-fledged criminal. Because no intervention was done for him whatsoever. So the law is good. I don't think it should be changed. What should be changed is the concept of the police that, it's so difficult to go after adults, let's just go after the child. And the concept of the local government who doesn't want to put the money where the law says the money should be put in.
So my last question, Atty. Legarda. How do you want to be remembered as the First Lady Chief Justice of the Supreme Court?
As someone who has always been fair.
Okay. On that note, I don't have any more questions for Atty. Legarda.
Thank you. Thank you, ma'am.
Justice Hermosissima.
Good afternoon, Atty. Legarda.
Good afternoon, sir.
I have been well acquainted with Atty. Legarda during my stint in Sandigan Bayan. She was an active practitioner then.
Yes, sir.
Although I can say that Presiding Justice Garcetorena was always in her favor because they are both of Spanish descent.
I hope that's not the only reason, Justice. I hope he was also in my favor because I always came well prepared to court.
Well, what subject in law is your forte?
Well, right now I teach persons and family law, Civil Law Review 1, Succession and Torts. And for legal ethics and for MCLE, I particularly I teach legal writing and legal ethics, Your Honor.
You realize, of course, that the Supreme Court is a court of general justice.
Yes, sir.
And so you don't specialize in any particular subject in law. Well, first things first. There are objections to candidates for the Supreme Court, the Chief Justice, who are so-called outsiders, United Judges. When Senator Miriam Santiago applied for the position of Chief Justice, I told her that I'm not objecting to outsiders applying for positions in the Supreme Court. Because I told her about Earl Warren, who, Governor of California, who was approached by Eisenhower, said, if you help me in your campaign, and if I succeed as President of the United States, I will appoint you to the first vacancy in the Supreme Court. It turned out that the first vacancy was Chief Justice of the Supreme Court of the United States, and so Eisenhower said, no, just Associate Justice is not Chief Justice. But Earl Warren said, if you have any sense of honor at all, you will appoint me to the first vacancy in the Supreme Court. And he was. And Earl Warren was appointed. It turned out that the Earl Warren Court turned out the best doctrines in law in the United States. Among them was this Miranda doctrine. That's his. So, considering your forte, is the same-sex marriage allowed as legally valid and constitutional in the Philippines? This is valid in California, it's valid in Oklahoma, but then...
And Massachusetts, I think.
Massachusetts. How about in the Philippines?
No, Your Honor, because in 1988, the Family Code specifically required a man and a woman to be qualified to marry. Prior to 1988, Article 52 of the Civil Code does not state the gender of the marrying parties. This came into effect under the Family Code in 1988.
Well, others say that it is in accord with human rights on the matter. How about this proposal to teach or sex education among grade school and high school students? This is opposed, of course, by the Catholic Church. What are your thoughts?
You know, Justice, I work with the Child Protection Network Foundation.
Or would you like to leave it to the parents to do it?
Well, the word sex education is not mentioned in the civil law or in the family code as an obligation of the parents. The problem is, Justice, we have one of the highest numbers of teenage pregnancies in the world today. We are almost at par with the United Kingdom, where they have child mothers. And the reason for that, and we are horrified at the Child Protection Network Foundation, that many people, many young children think that they won't get pregnant the first time, which we know is false. Many people do not understand actually what the act of sex is. We have children who come to us saying that they were raped. But when you ask the questions, what do you mean when you say that they were raped? It turns out that maybe they were kissed or hinipuan sila because they see in soap operas screaming, hair being pulled, kissing scenes, and then segueing into something else, and it turns out that a sexual act had occurred. This continued cloak that veils the act is not good, and I would prefer that the schools and properly trained professors take it on, because now what happens is that these children see it on the internet. We had an extraordinary study recently done, Your Honor, that 9 out of 10 children have seen pornography and the act of sex on the internet. And without guidance from both parents and schools, I think the problem is just going to be worse. So yes, I agree that there should be sex education according to the age of the child, relevant and appropriate for the age of the child from grade school up. Our greatest number of victims are at the ages of 13, 14, 15.
On another matter, Congress is now starting deliberations on the RH bill. As a Chief Justice of the Supreme Court, it is only proper that you have your ears to the ground, so to speak, and watch the issues that will most probably come up to the Supreme Court for consideration and judgment. Well, the foremost issue in the RH bill is, will it have to, the Supreme Court will have to resolve whether or not the RH law violates the constitutional provision which states that the state should protect the life of the unborn from the moment of conception. Is the use of condoms or contraceptive device prevent the implantation of fertilized ovum?
Yes, Your Honor. When the Constitution talks about the unborn,
what is your view? Yes or no?
Yes, Your Honor. The use of contraceptives, condoms, and did you say the pill, Your Honor?
I didn't say that, but it's part of it.
Sorry. Yes, the use of contraceptives prevents conception. And it is only when there is conception does the provisional personality of the child created. And it is that child who must be protected at conception.
So what is your view?
Well, my view is that the constitutional provision can still be employed in order to prevent damage and injury to a conceived but unborn child. That is where the protection will come in.
Well, on that note, thank you very much.
Thank you, Justice.
Secretary Mosngi.
Thank you, Attorney Ligarda, for your patience. I believe most of my questions have already been answered by my colleagues here, but I just have one more, if I may. Attorney Ligarda, you are recognized and perceived to be one of the leading champions of women and children's rights in the country today. There are, like Justice Hermosissima has mentioned, there are certain pending bills in Congress that may have direct implications on women and children's issues, which eventually the Supreme Court may be asked to adjudicate. I'd like to ask you, do you have any position on legislating divorce in the Philippines?
I have no position for legislating divorce, Your Honor, because first, we're the only country in the whole wide world without a divorce law. Even Malta, with the Knights of Malta, have a divorce law. Secondly, I don't understand the resistance to divorce, other than that the Catholic Church does not wish it to be passed, because the concept of declaration of nullity is better because there is no recognition that marital bonds exist. The concept of a divorce, I think, may be passed in limited sense. As human beings, people make mistakes. People are coming to family lawyers sometimes only after 6 months of marriage. It is just extraordinary. And you wonder when you look at these young people, 23, 24, 25, what is the life ahead of them if they are not given a second chance? My position on divorce is that it is time for us to have a divorce law. We can use the Article 55 of the Family Code, which are the grounds for legal separation, as grounds for divorce. Instead of saying na ayaw na namin sa isa't isa, so maghiwalay na tayo, which is the no-fault divorce, we don't need to go that far. But I think if we look at the statistics of our Filipino people now, 50% of marriages are in the courts for some reason or another. The Supreme Court itself, I don't know, the statistics of petitions for nullity of marriage coming before the Supreme Court is mind-boggling, and yet the court has actually only granted 7 out of the thousands that have come to the Supreme Court. And the Supreme Court are beginning to apologize for, I'm sorry that you have to live with a person who is so awful as this, but unfortunately, impliedly, your lawyer didn't do this properly. You know, the lack of juridical antecedents particularly is what affects nullity of marriages before the Supreme Court. So these people, forever, they're going to be married. And there is no escape except death. And that is why I always tell men who batter their wives, do not close your eyes at night, because the Supreme Court in the Marivic Henosa case has allowed a woman to kill you in self-defense. So why go to death when there can be an amicable settlement of marital life?
Thank you for that, Attorney Legarda.
Thank you, sir.
Chair, thank you, po.
You were talking about the case, you mentioned about the case of People versus Minerva Henosa. Yeah. I think you were the counsel?
I was appointed counsel de officio
By the Supreme Court?
By the Supreme Court, yes.
But you did not defend the accused before the lower court?
No, Your Honor.
But the Supreme Court said that at that time, there was no yet 9262.
None yet, Your Honor.
And therefore, Henosa was found guilty of the crime of parricide, but the penalty was reduced because of the presence of several mitigating circumstances. And the Supreme Court said that there is no yet law recognizing battered woman syndrome as a defense. Is that correct? Am I correct?
That's correct, Your Honor. That's correct, Your Honor.
Now, since the effectivity of 9262, which is the violence against women and children, can you recall of any case where a woman charged with the crime of parricide, she was acquitted on the ground that she killed the husband because she's a battered wife? Is there already a case?
Actually, Your Honor, if I may say so, none. You know why?
Yeah.
You know what the police officers do? After they've investigated and found out that she was a battered woman, they don't bother arresting her anymore. It's very interesting phenomenon, that 9262. They don't bother arresting this woman anymore. They don't bother putting her in jail. And they accept hook, line, and sinker that this woman murdered her partner because she had been a battered woman, which we have tried to address with the police officers when we train them, the women's desk. We tell them, you need to still file the case because they need to prove what the Supreme Court requires in the Henosa case, that you went through the cycle of violence at least twice before you can be considered a battered woman.
That's why it's really very hard to get an acquittal.
Yes, I agree.
If you really study the definition of a battered woman syndrome, in that case, you have to undergo 2 cycles, no? Now, my other question is, 90 to 62 is supposed to be protection to women and children.
And their children, yes.
And their children. But there has been some comments that 90 to 62 actually is discriminatory against men. Because a man is not entitled to a protection order. But there are also cases where the wife now becomes the beater. So there is now what we call man-battered syndrome.
Agree, Your Honor.
Yes,
Your Honor. Many of my clients were battered men.
What's then the remedy of the battered husband if the 9262 is only for the protection of women and their children?
Well, what I have advised battered husbands is that 9262 is also for the protection of their children.
Yeah, but
so they can seek a protection order on behalf of their children.
Yeah, for their children.
Yes, Your Honor.
But can the husband get a protection order against the wife?
No.
If the wife is the one causing physical violence, if the wife is the one causing economic violence because the wife keeps the money of the family.
Well, physical violence perhaps...
I'm referring to economic violence. There are 4 kinds of violence under VAUC, and one of which is economic violence. And it's economic violence where if the husband is the one keeping the money and does not want to give the money to the wife, then she can file violation of 9262 on that ground. But if it is the wife keeping the money and the wife does not give the money to the husband, can the husband go to the court and then ask for a protection order from the court? Of course, the husband cannot.
Well, he can go and seek to be made sole administrator of the partnership.
But that's a longer process.
It's a longer process.
You remember, Dr. Legarda, that you can even get a protection order before the barangay chairman.
That's correct.
If you go to the regular process, it is longer. In the meantime,
correct.
The husband does not have money to buy for his food.
That's correct.
Yeah. So do you think that there should be an amendment to 9262?
I do, Your Honor.
Oh, yeah.
I
think I agree with you. It's really unfair to the men.
Actually, Your Honor, that law was supposed to be the domestic violence law.
Yeah.
What happened was it was changed at the last minute. So if you look at the crimes, may nagging, di ba? Yung nagging, that's actually addressed to apparently us women.
Kasi kawawang lalaki, even stalking is now a crime under 9262.
Yes.
Following a woman whom you like and love, no? If you persist in following that woman, then the woman might charge you for stalking.
Right.
But if the woman is the one following the man because he's handsome, the man cannot file a case of stalking against the woman. Is it not?
That's correct, Your Honor. That's correct, Your Honor.
I think we have to amend the law.
I agree.
Yeah.
I agree.
Now, you were talking also about liability of minor children under 9344. You said that the law is good, no? But if you read the law on the exemption of criminal liability, no, you will find that there is only one instance, or there is only one group of minors who can be liable for the commission of a crime. Is it not? Because under the new law, if the age of the offender is 15 or less, totally exempt from criminal liability, but he will go
will he be released to the custody of the parents? Is it not?
And
Or to the DSWD and undergo some sort of reformation. I think it's an intervention program. Is it not? Okay. But if the age of the victim is between, the offender is between 15 and 18, he can still be exempt from criminal liability because in order to be liable, you will now have to establish discernment. And discernment is very hard to establish.
We're the only country in the world which has that in our law, Your Honor.
That's why I think there's a need to amend that provision. Because I tell my students that when I was 17, I said, I had already 4 girlfriends, but they did not know that they were my girlfriends, you know. No, seriously speaking, the problem is this, under the law. Who determines discernment?
Unfortunately, it's the social worker.
It's the social worker or the policeman.
Well, it's supposed to be the social worker, not the police officer,
but
Your
under
Honor.
the law, if the minor in conflict of the law is arrested by the policeman, is it not that the policeman can determine if he acted with or without discernment? Okay.
No, Your Honor. He's supposed
Is
to...
it the social worker?
Yes, Your Honor.
You can just imagine under the old law, when a minor acted with or without discernment, it is the court that determines. Because under the old law, if one is exempt from criminal liability, the procedure is that you have to file a case against the minor. Because the burden of proof is on the part of the accused that he was a minor at the time of the commission of the crime and that he acted with discernment. Is it not?
That's correct, Your Honor.
So do you think that there should be an amendment insofar as this aspect?
Actually, Your Honor, what needs to be added is a provision on a minor that commits heinous offenses. There's none.
Yeah, that's
There's
correct.
none. There's none.
That's correct.
And that should be added to the law. In fact, I think baka naligtaan nila or they
Kasi
forgot.
alam mo, sinasabi nila, Attorney Legarda, is that itong mga magagaling na sindikato, criminal syndicates, they are now using the minors, those less than 15 years of age, to commit the crimes for them. I think you're aware of these comments from groups like the violence against the group violence against the VAC, for that matter. They want this to be amended. I think there is really to amend that provision.
Yes, that provision. But I think, Your Honor, the Supreme Court is also attempting to kind of address this a little bit when you came out with your new rule on the juvenile in conflict with the law. I'm not sure if it has already been signed by the Supreme Court.
In fact, that was what I wanted to ask you.
Yeah.
Can the Supreme Court remedy the situation by using its rulemaking power to promulgate rules and regulations to address these problems?
Well, the Supreme Court has used it for the rule on examination of a child witness.
Yeah.
The Supreme Court has used it for the rule on electronic documents. The Supreme Court has used it for the rule on mediation and on declaration of nullity, separation of marriages, guardianships. The Supreme Court has used it, in fact, also in the rule on 9262.
Yeah.
You've used it. And I think you can use it, Your Honor, just to address the fact that minors who commit heinous offenses really need to go through a court process.
Yeah, that's correct. That's correct. It should be the court that should determine if a minor acted with or without discernment. It should not be the social worker. Yeah. Do you agree with that?
I agree with you, Your Honor.
So can you make the proposals for the amendment of the provisions later on?
I will, Your Honor.
Oh, yeah. Okay, thank you very much. On that note, thank you very much, Attorney Legarda.
Thank you very much, Your Honors. I know you've had a very, very long day. You've been very patient with all of us. Thank you.
Now, we will adjourn our session today. We will proceed tomorrow at 9 o'clock. Okay? Thank you very much.
Okay. Please all rise while the members of the Judicial and Bar Council leave the room.
liability. But he will go, he will have, will he be released to the custody of the parents? Is it not?
And
Or to the DSWD and undergo some sort of reformation. I think it's an intervention program. Is it not? Okay. But if the age of the victim is between, the offender is between 15 and 18, he can still be exempt from criminal liability because in order to be liable,